So, hello everyone. My name is Kerem Bilge. I'm a consul in Thompson Hine's International Trade Group. Welcome to today's SmarTrade Fundamentals webinar on tariff violations and evasion risks and the evolving enforcement landscape in the United States and the European Union. This is the second session in a five-part series focusing on the basics of import regulations and customs compliance. Today's session will explore the most common methods of tariff evasion, recent enforcement trends, and the legal frameworks governing customs compliance on both sides of the Atlantic. Before we begin, I must address a few housekeeping items. So first, today's program is being recorded, and we will send a link to all attendees of today's presentation in the next few days. And the presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions being expressed today are those of the individual panel members only and do not necessarily reflect the opinions of the panel members' clients, employers, affiliates, or Thompson Hine, or Van Bell & Bellis. And the content should not be taken as advice, as the views expressed here are for informational purposes only. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of the questions as we can, both during the presentation and at the end of the webinar. If we don't get to your questions, we can follow up with you after the program. We will be offering CLE credits for today's webinar, so please be sure to complete the verification of attendance survey. A link to the survey is included in the agenda that can be found in the related content section of the control panel. There is also a direct link to the attendance verification survey. I will announce the tracking code at the end of the program. And in the related content section, you can also download a copy of the presentation as well as bios of today's speakers. So today, I am joined by my colleague, Pablo Muniz, a partner and head of the customs practice at Van Bell & Bellis. And again, thank you for your interest, and we will get started. So we'll get started with the kind of like the U.S. aspect of the issue, the tariff violations, evasion, and like the enforcement trends, and then Pablo will address the trends and the issues in EU and from his perspective. So this agenda is basically like the kind of applies to the U.S. side only, and in this first slide to kick things off, you see various tariff actions taken by the Trump administration since taking office in January 2025. On the day of the inauguration, President Trump released America First trade policy memo that detailed various areas that the new administration will focus on in trade policy. And these included addressing unfair and unbalanced trade and economic security matters. And essentially with the directions provided in the memo, the Trump administration has taken various tariff actions that you currently see on this screen. And that increased significantly the overall tariffs applied to specific industries, specific products, or to essentially all countries overall. The IEEPA actions, the International Economic Emergency Powers Act actions, were taken to apply global reciprocal tariffs, which currently range from 10% to 50%, and to apply specific tariffs against Mexico, Canada, and China to address national emergency declared in connection with the imports of fentanyl and the illegal immigration um, that that was declared by President Trump in the various executive orders. And these tariffs are currently being reviewed by the Supreme Court, which is expected to issue its decision by the end of this year. And the administration also used this legal authority to increase tariffs against India and Brazil. In the case of Brazil, the President Trump declared a national emergency in relation with Brazil's persecution of the former president Bolsonaro and other issues, and on India due to the purchases of Russian oil by the Indian government and Indian companies. And then the administration also used the Section 232 legal authority, which essentially applies to national security tariffs, to increase tariffs on specific products. Obviously, the biggest one is the steel and aluminum tariffs. They were in place they were established during the first Trump administration, but during the second Trump administration, the scope of these tariffs were significantly expanded, and now they apply to various derivative products that incorporate steel or aluminum content. And the administration also imposed new tariffs, new Section 232 tariffs on various additional products like copper, like light vehicles, heavy trucks, medium trucks, and buses. And then finally the administration started new Section 301 investigations, like the one against Brazil or China's semiconductor policies, and threatened to apply additional tariffs like foreign digital services tax. And then this actually happened during the Biden administration, but the Section 301 tariffs that applied to virtually all products from China were expanded in late 2024. So overall, the Trump administration has significantly increased the amount of tariffs that apply to overall almost all products and all countries. And on this slide, you see the trade statistics that we pulled from the CBP's website. They're current through August and end of August 2025. And as you can see, the total amount of duties collected in 2025 through end of August is almost more than double of what was collected in total year 2024. And it's reasonable to expect that the total tariffs will probably exceed $300 billion at the end of 2025, which is essentially going to be almost 3-4 times more than the duties collected compared to 2024. And then on the other chart, you see the duty amounts collected in connection with each tariff action that I had identified in the previous slide. I mean, the magnitude of these tariffs is really notable. Like, for example, in the case of steel and aluminum, there was a huge increase, almost 4 times increase in steel tariffs duties collected, and then almost 8 times increase in the aluminum tariffs, and then additional duty revenue received from these additional tariffs the IEEPA tariffs. So, and then in the last kind of statistics slides, you see the effective tariff rates that was calculated by Yale's Budget Lab. So in January 2025, before the Trump administration took office, the effective tariff rate in the United States was 2.4%. And now, as of the end of October, as of I think October 18, the effective tariff rate is 18%. And this obviously has increased the tariff liability on a lot of companies, and also it will, as we will discuss today, it will increase the enforcement of these tariffs by the administration, because these high tariffs have created significant incentives for companies to take steps to reduce duty liability as much as possible. But if it's not done right and consistent with laws and regulations, these steps may expose companies to significant civil and criminal enforcement and penalties. And the Trump administration has made trade enforcement one of the first priorities and significantly increased the enforcement capabilities to address trade violations. So essentially, all these things together set the stage for increased risks for companies due to potential customs non-compliances. So on this slide, you see sort of like the key areas for enforcement and almost like common customs violations that lead to enforcement actions. The first one is like false country of origin and transshipment. Customs laws have like legal standards to determine the correct country of origin when a product incorporates hundreds of different components from multiple countries that are ultimately assembled in a third country, and the importers may be at risk of misrepresenting the correct origin if the third country operations, like assembly operations, do not satisfy this legal threshold. And the second one is classification issues. Obviously, identifying the correct HTS classification, the harmonized tariff schedule classification for a product can be a daunting task, and declaring an accurate HTS classification could lead to lower liability. Inaccurate HTS classification could lead to lower duty liability in certain cases. For example, the steel and aluminum derivative tariffs apply to certain HTS codes, and if, for example, importers attempt to reclassify their products to avoid these tariffs, then they may be at risk of potential civil or criminal enforcement if such classification ends up being inaccurate. And then I think it's kind of like related to that, the AD/CVD issues. It's really common for importers to like misrepresent the country of origin or misclassify the products to avoid anti-dumping or countervailing duty liability, because that's how the CBP administers the duties at the border, and the like inadvertent violations of the law that may lead to reduced AD/CVD liability may end up being an enforcement issue for companies and significant risks for companies. And then valuation is obviously another topic. It's a common issue that is addressed by enforcement measures, declaring, for example, a lower customs value than what is called the transaction value, using various like schemes like double invoicing schemes, or omitting like certain costs that should be part of the declared value, like, I don't know, like royalties, can lead to potential civil or criminal measures. And then finally, FDA abuse is another common kind of like topic for enforcement actions, misrepresenting the production process, tariff shift, or value-added content may lead to kind of like FDA abuse, meaning like, for example, getting the duty-free benefit of a free trade agreement like USMCA, but at the end, if not done right, that could lead to another enforcement action risk or duty liability for companies. So just to give you like, I guess the background, there are like two primary agencies that are involved in enforcement of the customs laws and regulations. The first one is obviously Customs and Border Protection, CBP. CBP is primarily involved in the civil enforcement of the customs laws and regulations, and the DOJ, Department of Justice, can be involved in both civil and criminal enforcement. Both agencies can act against domestic or foreign companies. They have authorities to do so under certain cases. And the enforcement actions could include both companies and individuals. This is like 19 USC 1592 is essentially the main statute that provides the legal basis for civil enforcement actions by CBP or in some cases DOJ. The statute prohibits the importers from importing products with false documents, false statements, or material omissions. And these essentially include all common violations that we previously discussed in one of the earlier slides. And the liabilities of this statute primarily attach to the importers of record. But the statute also allows actions against persons that aid certain violations. So it may actually extend beyond just the importers of record in certain circumstances. One example is that, like, for example, foreign exporters who knowingly assist the importer of record in committing fraud could be liable under the statute. And then finally, both kind of corporations and individuals, again, can be liable under the statute, and penalties may be imposed without regard to whether the trade violations resulted in any underpayment of duties or taxes. So in this slide, you see sort of the maximum penalties that may be imposed under the statute against for trade violations. So for fraudulent violations, the CBP can impose penalties up to the domestic value of the merchandise. And for gross negligent violations, this is up to the lesser of the domestic value of the merchandise or 4 times the loss of duties. And if there was no duty loss as a result of the violation, then 40%, the maximum penalties could be 40% of the dutiable value of the merchandise. And then in negligent violations, the maximum penalties are lesser of the value of the merchandise or 2 times the loss of duties. And if no duty is lost, then 20% of the dutiable value of the merchandise. So it's important to emphasize that, like, these penalties can be mitigated by importers using various measures, including filing a customs prior disclosure with the CBP. And when an importer, like, properly prepares and timely files a prior disclosure, they can limit their liability from these violations to essentially only the underpaid duties and interest, the applicable interest. And the timing is essential because prior disclosures, the safe harbor under prior disclosures is available only for violations before the commencement of a formal investigation by CBP. So essentially, the longer a party waits, then the likelihood of CBP launching an informal investigation is going to be higher, and that's when that happens, that will foreclose the importer from getting the benefits of the safe harbor here. And the statute of limitations for negligent and gross negligent violations is 5 years from the date of violation. So essentially, if you're dealing with sort of like a negligent or gross negligent violation, once you report that, you would essentially be required to go back 5 years and address the issue and pay the underpaid duties and interest, and then you will be able to, like, get the benefit of the safe harbor and avoid any additional penalties from the CBP. So, yeah, like on this slide, you see kind of a bunch of enforcement tools that are used by CBP and other agencies to address trade violations. So CBP can issue CF-28s, Customs Forms 28s or 29s. 28s refer to essentially requests for information from an importer regarding specific entries to identify or confirm whether the importer at issue is committing trade violation. And 29s represent notices of action. And obviously, CBP can conduct customs audits or investigations to identify and address possible trade violations. I guess it's important to emphasize here that, like, when an importer, when you guys receive a CF28 or 29, the best practice is to, like, immediately seek counsel and evaluate whether any corrective action is necessary. This can be in the form of ruling requests or prior disclosure or whatnot. And in addition to that, the CBP may receive information from other parties resulting that could result into, like, investigations concerning these trade violations. E-allegations portal allows, for example, any party to report trade violations about alleged violators, and these allegations can be provided by anyone, essentially, and you can even provide anonymously, and they can lead to potential investigations and enforcement measures. And then for violations relating to anti-dumping or countervailing duties, CBP allows interested parties to submit EAPA, Enforce and Protect Act allegations against importers suspected of evading the duties. And in this case, like, interested parties include foreign manufacturers, foreign exporters, or, like, competing importers of the same merchandise, as well as the domestic manufacturers or trade associations that are involved in the same business, in the same product. And if CBP finds reasonable suspicion of evasion, then it can impose interim measures requiring the payment of AD/CVD duties going forward, and also suspend the liquidation of the previous entries and apply the AD/CVD duties to those entries retroactively. And then another kind of, like, tool is the anti-circumvention inquiries that are dealt with by the Department of Commerce, another agency, and they conduct these, like, inquiries, anti-circumvention inquiries, or even in some cases scope inquiries, to address the circumvention of the anti-dumping or countervailing duty orders. And if there's an affirmative finding of circumvention, Commerce can extend the scope of these trade remedy orders to products processed in third countries or to certain companies that are found to be circumventing the orders. And then I think the last one, and it's quite kind of punitive, is the False Claims Act. That is another basis for civil customs enforcement. The FCA is a highly punitive statute that prohibits fraud or false statements made to the government. And it's commonly used to address trade violations, especially in recent years. And it could lead to treble damages, as well as the imposition of penalties for each violation. And it's also essentially like a whistleblower statute, in that private parties can file qui tam actions on behalf of the government and receive up to 30% of the total award. So it's and the FCA activity in recent years has significantly increased, and I will discuss this later today. But the DOJ is also increasing its resources to kind of address trade violations using this legal basis. And one additional point that I think is important is that the potential liabilities in FCA cases is really not limited to importers of record, but foreign exporters or even the U.S. purchasers of the product could potentially be exposed to liability in certain cases. And you see here the criminal penalties that may be imposed for customs violations. Obviously, these are limited to sort of like fraudulent cases, The key statutes are here, like 18 U.S.C. 541 through 555. These include kind of like prohibitions against knowingly importing goods with false certifications, classifications, or information, etc., or to smuggling goods with intent to defraud the United States. And the fines and penalties could be up to like 20 years of imprisonment for some offenses. And then the criminal charges can be brought alongside with civil penalties, and there are various examples of that in the past. So I guess like the recent enforcement policy is sort of like the most important issue here that we're discussing today. The increased enforcement of like trade violations is a priority for this administration. And the basis for that is because the administration views these trade violations as a national security issue and as an America First issue, essentially. So there was a memo released by the DOJ back in May. It was called Focus, Fairness, and Efficiency in the Fight Against White-Collar Crime. So that memo lists like 10 high-impact areas that the criminal division of the DOJ will prioritize in investigating and prosecuting white-collar crime. And the trade and customs fraud was listed as one of the high-impact areas that the DOJ will focus on. And then the memo explains that trade crimes are a threat to the U.S. economy and to American competitiveness and national security. So that explains all like why they're essentially like prioritizing trade violations as a high priority enforcement issue in white collar space. And then consistent with this goal, the DOJ also announced a new like trade fraud task force that involves a partnership between the DOJ's criminal and civil divisions. And so increased enforcement will really not be limited to the like civil criminal matters, but we expect to see increased activity on both on like the criminal side as well as on the civil side through like the False Claims Act and penalty provisions under the Tariff Act. And then these like announcements, these press releases also encourage the whistleblowers to utilize either the criminal division's whistleblower program or the key 10 provisions under the False Claims Act to report violations to the government, and also encourage companies to self-disclose and remediate violations if they find any kind of like trade non-compliances as they are reviewing their records and verifying their previous statements. So this is, I think, like kind of important to emphasize also that like various tariff-related executive orders and proclamations mandate like strict enforcement of tariffs. And like, for example, on this slide, you see the aluminum and steel proclamation from June 2025. And it essentially instructs CBP to issue guidance on mandating strict compliance with declaration requirements for steel and aluminum content, and that like if importers submit underreported declarations, they may be subject to severe consequences, including but limited to significant monetary penalties, loss of import privileges, and criminal liability. And then in the next slide, you see the executive order from July, which applies to reciprocal tariffs. And then in that kind of like proclamation, the president stated that the products that are determined to be transshipped to evade the reciprocal tariffs will be assessed an additional 40% duty and should not be allowed to mitigate penalties. And this essentially refers to the prior disclosure benefits, the safe harbor that would otherwise apply to these violations. And then in this slide, you see some like recent examples. the first one relates to like an auto manufacturer that agreed to pay back in 2024, late 2024, a significant amount of penalties to resolve alleged trade violations involving misclassifications and undervaluation related to imports of certain vehicles. Essentially, the vehicles were imported as passenger vehicles, which was subject to 2.5%, I think. And then in reality, the vehicles were cargo vehicles and were made, the importer made some like post-importation changes in the vehicle to sell the vehicles as cargo vehicles, which would have been subject to 25% duties. So the CBP started an enforcement action and they made a settlement with the manufacturer for this amount to resolve those allegations. And then the second one was from March 2025. So the reason I put it here is because like it's like an $8.1 million settlement that related to allegations of transshipment, and the case was initiated by a competitor under the FCA provisions, under the KITAM provisions of the FCA, and the competitor ultimately received $1.2 million as an award for providing that information and for initiating that case. And then the last one relates to another kind of another like CBP enforcement issue, and the importer had to pay $6.8 million in penalty, to settle the allegations of undervaluation and transshipment issues. The kind of like importance of this case was that it was initiated by a self-disclosure by the importer to CBP and the DOJ, and that essentially significantly reduced the penalties that the importer had to pay as a result of these trade violations. And in fact, I think it's like the $4 million of that 6.8 million was actually the underpaid duties. So it just like highlights the importance of being proactive and like self-disclosing your violations to the government when the importer discovers those. So, and on this slide, you see some sort of like takeaways and best practices for like trade compliance. Obviously, having a robust compliance program and training is essential. And then conducting regular audits and reviews and verifying the classification, country of origin, valuation of goods and products, and also preferential treatment eligibility claims is essential because, I mean, essentially, like you may not know that there might be various violations that were committed inadvertently in the past, and it's crucial to like do these like periodic assessments addressing your like historical import activities, and to make sure that you stay on top of these kind of customs compliance issues. And then when you discover any sort of like violation, it's really important to be proactive and self-disclose to the government as soon as possible because of the reasons that I explained in connection with the prior disclosures. And then when you kind of like, especially in this high tariff era, it's really important to maintain clear supporting records and documentation, where in the case of like, for example, aluminum tariffs, you really need to have like the accurate records from the suppliers or like from your like internal accounts showing the calculations made that to arrive at the steel content or like the aluminum content that was eventually declared to CBP, because it's really likely that CBP may come back and ask questions about your previous declarations and even conduct an audit to make sure that the companies are in compliance and remain in compliance with the laws and regulations. And obviously, in all these kind of like throughout these stages. Make sure to contact your like internal compliance teams and legal counsel for support as needed. So I will kick this over to Pablo to talk about the EU aspect of these issues.
Thank you, Karen, and good morning or good afternoon, everyone, and thank you for the invitation to join. To the introductions about myself, I will only add that although we are based in Brussels, we assist clients in customs audits in different member states, which also gives us an overview of what's going on throughout the European Union. And I will address the topics or the topic that Karen addressed, but from the point of view of the EU. You may consider that there is no proliferation of tariffs in the EU as it has happened with the US. As you probably know, the EU did not impose retaliatory measures on goods from the US. And you may perhaps conclude where the risks are lower in the EU. I would say that the risks are the same that for the US, and that the need to comply are as important as ever. And this is because as a result of the proliferation of tariffs in the international trade, the activity of the EU imposing trade defense measures, like, for example, anti-dumping duties, has increased considerably. I think for this year, we are, I would say, in a record year on cases imposing anti-dumping duties or other trade defense measures. And that means that there is also an interest on the customs authorities to make sure that those measures are correctly applied. As a second element, because of the tensions between the EU and the US, the EU has increase the efforts to conclude free trade agreements with third countries. That means that there will be more and more free trade agreements, and therefore also an interest on the customs authorities in the EU to ensure that the free trade agreements only apply to the goods having the correct origin. And a third element which makes enforcement important is, as you know, as part of the deal between the EU and the US, the EU will suspend duties mostly on industrial goods, but only on those with US origin. And again, there will be an interest in auditing those imports and making sure that only the correct goods benefit from that suspension. So, as I said, even if it may look we don't have the retaliatory measures, there is a lot of interest, and enforcement is also a priority in the EU, despite not having retaliatory measures. And how I have structured this is, I will refer first to the scenarios where you will see potential compliance issues. Then I will refer to the players in the EU which are active in the investigations. And I will end with a reference to what we call the EU Customs Anti-Circumvention Tool. And for the scenarios, it's a bit in line with what I mentioned in the introduction, but I wanted to visualize it here so you can see that when you are importing EU goods into the EU, if we are looking at the future suspension of the duties on US goods, there will be an interest on the customs authorities to make sure that the goods that are processed in the EU, in the US, are US origin goods. So there will be checks on whether the processing in the US is not minimal processing or insufficient processing that we call, that the origin was not wrongly declared, and obviously that there was no transshipment, that goods were not transferred from a third country to the US and then sent to the EU as pretending to have US origin. If we look at third countries with which the EU has trade defense measures like anti-dumping duties, the customs authorities in the EU will have an interest in ensuring that, first of all, the classification of the goods is correct, because that will also determine to a certain extent the application of the trade defense measures, or that the origin of the goods has not been declared incorrectly. And if we look at countries, or if you are trading with countries where there is no trade defense measure, but there is a free trade agreement in place, the customs authorities will be attentive to incorrect declarations of origin, again, transshipments or processing in those third countries, which amounts to minimal processing and therefore does not confer origin. And it's true that all these scenarios have a lot of emphasis on origin matters and classification related to the origin. But we also have to bear in mind that the general customs audits remain in place. And that will concern, as also Karen explained for his part, classification, origin, and valuation. And on classification, I must emphasize that classification, perhaps for a while, was not always so important if you were looking only at the tariff, because perhaps the applicable duty was 0%. But as a side comment, you should take into account that there are quite a number of measures in the EU now that are applicable based or will be applicable based on the tariff classification. That's the carbon border adjustment mechanism, that's the EU deforestation regulation, sanctions as well. These measures rely on the classification. So regardless of whether it has a duty impact, the tariff classification is becoming more and more important, and it's also the target of the customs audits. A couple of words about the EU proposal in August to suspend the duties on mostly, as you see here, industrial goods, but not only. This is part of the deal between the EU and the US, and it's still being, it's only a proposal from the Commission, but I wanted to mention it because this suspension of the duties will apply to goods which have non-preferential origin, US, according to the EU rules. But this is only until the moment there is a set of preferential rules agreed between the EU and the US. So you should watch that space, because there will be a negotiation between the EU and the US to determine the rules of origin that will ultimately apply to these goods benefiting from this suspension. And what I think is perhaps the important element for you to recall today is the players. And I would usually refer to three players, one of them relatively new. The first one is the European Anti-Fraud Office. This is part of the European Commission, and it has the competence to investigate frauds, and I use the word fraud because it's in the title of the agency, but it doesn't need to be a fraud in legal terms. It's any type of infringement. And it concerns what we call the EU financial interests or EU resources, which include customs duties. That means that Olaf is competent to investigate customs infringements. I will develop a bit each of them in the next slides, but first we have the overview of the players. The first one is the Olaf, the European Anti-Fraud Office. The second one is the European Public Prosecutor Office. This is relatively new, from 2021, if I recall properly, and it concerns criminal cases. This organization is only in charge of criminal investigations. And then we have, of course, the national customs authorities of each EU member state. They can also initiate customs audits under their own competencies. So let me refer first to Olaf. Olaf, it's an investigation unit of the Commission that can carry out on-spot checks and inspections in the EU, but also, you should know, in non-EU countries. And I will refer to an example in the next slide. They support the European Public Prosecutor when needed, and Olaf works together with the customs authorities of the member states. And yes, they issue recommendations at the end of the investigation. But these recommendations, even if they may not be, strictly speaking, legally binding, they will be followed by the customs authorities of the member states concerned. Why? Because those recommendations will conclude customs duties have not been collected in these member states. So here is my report addressed to the customs authorities of the member states, please collect the duties. If the customs authorities do not collect the duties, then the Commission will ask those member states to provide those duties from their own budgets. So in most cases, there are exceptions, but it's very unusual, the customs authorities will implement these recommendations. And I think if you see in this example, this is how usually these investigations will take place. You have a supplier in the US, then you have, they are obtaining goods from, let's say, Vietnam, and these are sent to the customers of the US company in Europe. Usually, Olaf will will look for information that could be information provided by a third party indicating that there is a potential fraud. It could be statistics. For example, if they see that there is a lot of, there is not enough raw material coming into Vietnam, but there are lots of finished goods coming out, it means that potentially there is a fraud. And then Olaf will send an invitation to, in this example, to the authorities in Vietnam to have a joint investigation. And Olaf, usually the country of export will agree. It's very rare that they will oppose that. And then Olaf, together with representatives of some customs authorities in the member state and authorities in Vietnam, will visit the factories of the suppliers and will review, for example, in this case, the origin. Once the verification is done, there will be this final report. And in that report, if the conclusion is the origin is incorrect, for example, it was Chinese, and that means that if the free trade agreement will not apply, and if there were anti-dumping duties on Chinese goods, the anti-dumping duties will apply. And in this final report, there will be a list of all the importers of those goods in the EU, which in my example will be customers of the US supplier. And the report will be sent to the customs authorities of the member states, and they will go to each of those importers in the EU and collect the duties. They will follow the procedure under national law, but in most cases, they will almost automatically apply these OLAF reports. So that means that the importers, which are the customers of the US company, will be probably picking up the phone and asking, what's going on? Why do I have to pay these duties? And whenever you see this, is the time to take it seriously and start getting legal advice, because it's important to have a good strategy from the outset. I give you some examples that you can click on. I think this is, you can click on the links. There are multiple examples of OLAF investigations. But I also wanted to mention EPO because this is a new institution, but which is extremely active. And I cannot emphasize enough how active they are. If you register for their updates on the website, you will see that they have cases almost every day. They are capable, if you look at OLAF, they need to send the instructions to the member states. The advantage of EPO, for EPO, is that they have representatives in the various member states which are part of this organization, which are 24 for the moment. They have a legal representative in those member states that can initiate criminal cases. So they do not need to get instructions from that member state. This public prosecutor in each member state is able to act independently, and they can directly initiate criminal cases. The caveat is that the competence of EPO is limited to customs infringements where there is intent. So it's intentional infringement. But there is always a risk that this notion may be interpreted very broadly. And as I said, EPO is extremely active. Again, you have an example here that you will get when you get the presentation. You can click on this. And I have to say, you still have the general customs audits by the national administrations. I cannot give you an overview of sanctions like Karen did because customs penalties in the EU are not harmonized. Each member state will decide, has their own rules. And in some cases, there will be no sanctions. In some cases, there will be criminal or administrative sanctions, depending on the facts. But in some member states, every customs infringement is potentially a criminal case. So mistakes or incorrect or customs infringement can become very serious. And to give you an example, for example, in Belgium, the penalty can be 1 to 10 times the evaded duties. You can go back in the collection of duties 3 years if it's not a criminal case. And if it's a criminal case, depending on the member state concerned, you can go back between 5 and 10 years. And conscious of the time, I wanted to refer to you to what I called before the EU Customs Anti-Circumvention Tool. You have this is a provision that concerns matters of origin. Imagine that you want to relocate your factory to another country to avoid the imposition of additional customs duties, usually trade defense measures or retaliatory measures. This is a non-preferential origin provision. If that relocation took place with the purpose of avoiding the application of those trade defense measures, the provision indicates that the transformation is not economically justified. And that means that even if, for example, you move production from China to Vietnam, and even if you meet the rule of non-preferential origin to acquire origin Vietnam, if it was done for the purposes of avoiding the anti-dumping duties on China, for example, you will be denied the origin Vietnam. And the origin will be determined based on the major proportion of goods, of components in those goods, which most likely in that example will be China. And it applies retrospectively. So I think it's important to take into account this provision whenever you are planning any kind of relocation. Harley-Davidson is a ruling from the Court of Justice, which unfortunately gave a very expansive interpretation of this provision. It confirmed that if the principal function was to avoid the policy measures, the origin will be denied, and it has to be assessed as why you took that decision at the time the decision was taken. You cannot correct the decision at the later stage. And I wanted to finish with this slide because here there is a kind of evolution of how things were happening in terms of audits, in particular for origin. If you have anti-dumping duties on China goods, in the past you could move the production, for example, to Vietnam, and there will be an audit to check if the goods had origin China or Vietnam. And sometimes the goods would have origin China, so the anti-dumping duties would apply retroactively. But then the policy was, okay, I moved to Vietnam and the goods have origin Vietnam. So the EU could start an anti-circumvention investigation as a trade defense policy to extend the duties applicable to Chinese goods to anything coming from Vietnam. That's not retroactive. But the new policy was to apply this anti-circumvention tool, which is very actively applied by the EU. And that means that the authorities will go to Vietnam and will say, well, okay, you move to Vietnam. Yes, you change origin. It's not Chinese, it's Vietnam origin. But because of this customs anti-circumvention tool, because you moved to avoid the trade defense measure, I'm going to deny the origin Vietnam. And if most of the components have origin China, you will have to pay the anti-dumping duties. So I cannot stress sufficiently that this is a very powerful provision, which unfortunately is being used more and more often. And as takeaways, to stop here, I will not repeat what was said by Karen, but its similar takeaways will apply for the EU. Taking into account that once you make your audits, your internal compliance for the US matters, it makes sense to do this also in parallel for the EU and have it as a global project. And I will pause here, Karen, to leave some time for questions and discussion. Thank you.
Thanks, Pablo. We do have a few questions. First, the question is would it be possible to share links to read details of the violation examples cited during the presentation? I think, Pablo, you already had the links on your slides. I didn't do that, so I will make sure that we add the links to the DOJ press releases. of the kind of U.S. Enforcement actions, and we'll make sure that you get the links. And then the second question is, a company found that some entries didn't correctly show payment of reciprocal IEEPA tariffs. Issue will be rectified. Could this be due to a broker or a system error? How easy is it for others to miss or avoid these duties intentionally or not? I mean, I think this is like a U.S. question. Yes, it's possible, and I think the brokers often make mistakes, and just like everybody does, and that's why, to our earlier point that Pablo also made just now, that like it's important to like audit yourself and like verify your records and like review your records, verify that they're correct on a periodic basis, so that you discover these mistakes if they occurred and report them or like fix them, to make sure that like you kind of like prevent like a larger liability in the future. And there are various ways to fix those, right? Like in the United States, you can do a prior disclosure, you can do a post-summary correction, etc. So there are tools for you to like kind of fix those issues. The important thing is like for importers to be like on top of their import activities and periodically review them to make sure that they're like accurate, essentially. And then Pablo, I think this is a question for you. So, you know, like with the upcoming EU customs reform, do you expect any changes to customs enforcement?
Yes. Well, first of all, the customs reform, it's still ongoing. It's still under discussion. And the initial Commission proposal had a proposal to harmonize customs penalties and infringements. That was dropped from as you may know, some of you may know, once we have a Commission proposal, the legislative process is complex, but needs to be discussed now between what we call the Council and the European Parliament. So basically member states and the Parliament. And there is an interest. Initially, the topic was dropped from the Commission proposal, but now it's back. So it's possible that we will have a discussion on some general principles on customs infringements. But also, in a certain way, the overall underlying element of the customs reform is to ensure a more uniform enforcement, I would say, because there is a lot of importance given to for example, have some kind of common risk assessments, and then on that basis, initiate customs audits. So with the customs reform and the creation of the future European Customs Agency, also that's a terminology that may sound very, you know, like it's going to be a centralized customs agency, well, with some powers, but those powers are now focused a lot on risk assessment, which will help or will make the enforcement more efficient, probably. So that means that you still have to be much more diligent. So yes, I think we would go towards a more uniform enforcement. And just a quick comment on the disclosures, maybe. In the EU, you can also make a disclosure to make corrections. But you should look at it before you proceed, in the sense that it depends on the member state concerned. In some cases, it's clearly stated in the law that you will have immunity from fines. In other cases, it's not clearly stated on purpose, and it will be taken into account. And usually it is, but you may not have 100% guarantee. But it's an option worth exploring if you discover something. Okay,
thank you. That's really insightful. So for those of you who are seeking the CLE for today's program, the tracking code is TH3167. Again, the tracking code is TH3167. So yeah, I think we're at the top of the hour, so we can end this. Thank you so much for joining us. And I hope you like the discussion, and you can reach out to either of us if you have any additional questions about the topics that we just discussed. And you can find our contact information in our bios in the registration page.
Thank you, everyone.